Community Bank. This is a possessory suit we filed this morning, but we gave advanced written notice to the defendants that we were filing the suit this morning and that we were going to seek an audience from Your Honor about an application for expedited writ of possession for 2 pieces of construction equipment. And per the statute, if they don't show pursuant to the letter notice to them, and we have proof of delivery, UPS proof of deliveries that I can leave with the court. But if Your Honor could just look at the matter and perhaps make a decision on whether the application's proper for expedited writ before the court today, I can leave it with you. My number is listed, but again, if your office doesn't have a record of it, I understand.
We don't have any record of your assistant supposedly contacting my office. So I don't know if they contacted one of the other judges, but
Your Honor,
Yes.
I did send an email to all the other judges' assistants and the clerks, requesting the case name so I could research more thoroughly in my email as to whether I approve something like this, but I always copy the clerks when I approve anything to be added to the docket. So far, 2 of the other 3 judges' assistants have said they don't have an email in regards to this case. And I've not been able to find anything in my email.
So you have not spoken to anyone from the plaintiff's firm, is that correct?
My assistant, Your Honor, is Miss Elizabeth Gray. And again, what we try to do with these is normally what happens is the suit gets filed, the application would then at some point in the morning be presented to the chancellor. Your Honor could look at the verified complaint that's been filed in support of the application for expedited writ. But
I'm just concerned about the fact that it's being represented that someone spoke to my office and set this up to be heard, and we don't have any knowledge of it. I just want to clarify, how that came to be and find out who it is that they talked to, and so that we can clarify that issue. If you want to leave your file with me, when I'm concluded with court, I'll take a look at it.
That would be fine, Your Honor. And you've got my information in the application, the bond, the writ of possession, the order granting the writ are all attached. I can also leave for Your Honor these 3 proofs of delivery. Is that they had noticed that we were going to be seeking this application today, Judge. Thank you, Your Honor.
All right, we're back on Butler versus Butler from yesterday. It was ready to believe your client had just finished testifying. Is that correct? Do you have any other proof? Mr. Butler, this is your opportunity. The plaintiff has rested on their ground for divorce, and this is your opportunity to present any proof that you wish to. Do you want to testify? All right, are you chewing gum? All right, spit it out before you take the stand, if you will. You come up. Raise your right hand and be placed on the oath. Thank you. Have a seat. Make sure you speak up loudly enough for the recording equipment to pick you up, okay?
Yes, sir.
All right, this is, like I say, you are representing yourself, so this is your opportunity to tell me what, you can respond to the statements that she made under oath about what happened. You can testify about what you want me to do regarding the divorce, the property division, and any kind of custody arrangements.
Yes, sir. So on the I guess we'll just go kind of going down a timeline like they did yesterday. So on the Mother's Day incident.
Let me ask you this question before we get started, and please bear with me. Do you have any pending criminal cases that are pending right now?
I do, that I'm taking to trial, yes.
All right, you have a case that's pending?
Yes, sir.
And what kind of case is that?
I was at the hospital being treated for poison ivy. And she showed up there and saw my car.
I'm just asking you, what's the charge?
Oh, stalking.
All right, so you have a pending stalking charge.
Yes, sir.
All right, you need to understand, and it's my duty to inform you of your rights. every person who is going to testify has a right under the Fifth Amendment of our Constitution to decline to answer questions or to offer testimony if those answers or that testimony might tend to incriminate them in criminal conduct. In other words, if you testify today and you're asked questions about the events that led to that stalking charge, then your answers could later be used against you, and a recording's being made of that. So it's available to the district attorney's office to use that as evidence against you in that criminal case. Do you understand that?
Yes, sir. Thank you.
Do you understand then that if you can either refuse to answer questions about that by invoking your right under the Fifth Amendment to decline to testify. You can avoid testifying, on direct when you're telling me what it is. Just don't tell me anything about it. But Ms. Brady Wilkerson has the right to ask you questions about that. And she can ask you a question after question after question. And you either answer the question or state that you decline to answer that question under the Fifth Amendment. Do you understand that?
Yes, sir.
Right. I've advised you of those rights. You're representing yourself. What happens from here on out is on you. You understand that?
Yes, sir.
All right, then go. Do you have any other witnesses that you intend to call?
I don't.
All right, no other witnesses. All right. Then, Mr. Butler, I'm ready to hear from you.
Yes, sir. So going back to Mother's Day, 2024, that weekend, me and Aaron were kind of having an argument, and I didn't realize that this at the time. She had been coming off. She stopped taking her antidepressant medicines, and she was very emotional that weekend. And I didn't realize that weekend, and it wasn't until later. And there was multiple attempts of trying to reason and kind of talk her down, and we couldn't come to an agreement. So it was that Sunday, once I realized we couldn't work anything out, I decided to take my other two children home. So that way she was yelling a lot that weekend, and I didn't want them to be, I've been trying to hide them from that. And so I ended up taking them home early and dropped them off. And instead of going back home, I sat in the car for a bit, and I wrote in my journal, and then I went home to give everything time to cool off. Anyways, and so I did, and when I saw her, I approached her, and I tried to amend the situation, and she just didn't really want to talk to me. So again, I left. And then I came back about an hour later, 2 hours later, I can't remember exactly how long. And she was just yelling and screaming, and eventually it led to the cops being called. And I did get the body cam footage of that, if I'm able to submit that for evidence of that night. And Aaron is telling the cops that multiple attempts I've tried to defuse the situation, multiple times. And she does admit to putting her hands around me. She grabs me by the throat, and then her eyes get big and she realizes what she's doing, and then she just rips my shirt. And so, when the cops got there, I refused to talk to them. I didn't want to incriminate myself, one, and two, I didn't want her to go to jail. After going through what I've been going through, I wouldn't want that to happen to anybody. But I ended up going to jail because I didn't give him my ID on private property. And then it wasn't until later, like when I first got to jail, they didn't even know what they were going to charge me with. It took them a while to even figure that out. He said I was drinking alcohol that night, and I definitely was not drinking alcohol that night. I know that I wasn't, and I asked him for a breathalyzer, and they would not give me one. And so then now going a month later, it was August, I think it was August. The cops had came out to our house again. It was the morning, we were set to go to Montgomery Bell State Park that morning. And that morning I was trying to talk to Aaron, like, because there's been a lot of friction between the two of us. And we were supposed to go to the state park with our son. And I was trying to kind of ease the situation so it didn't feel so tenseful, especially for our son while we're there. And she was just very hostile and just didn't I was gonna say just I don't know, just kind of trying to like shut me down like at every angle and just trying to like make me feel wrong. And then so I just kind of went about my business, you know, doing my own thing throughout the house. And she was, you know, doing her thing. And at and you know, there had been a lot of yelling. And so she was in the bathroom doing her makeup, and I approached her and I said, "Do you mind if we talk?" And at this moment, I was just kind of like slowly shutting the door. And she said, "You're trapping me in here. You're trapping me in here." I said, "No, I'm not." And I quickly opened the door and I quickly moved my body out of the way. Okay. And and I got out of the bathroom, and she calls the cops, and the cops come, and she tells them that I was false imprisonment to her, and I was keeping her against her will. And quickly the cop and the sergeant came out, and I got the body cam footage for that too. I would like to submit. And they quickly realized that she's trying to amp the situation up, which has been kind of like the theme. And so anyways,
So were you charged that night?
I was not charged, Your Honor. No, sir. You know, because they realized what was actually going on.
Just saying, you can't tell what somebody realized, nor can you repeat what they said, because that's hearsay.
Yes, sir. So no,
Tell
yeah.
me what do you want to do about you have one child with this?
Yes, sir. So I do have one child with Aaron, and I do have two children with another. And I just would like to get 50% custody. Me and my son Ryan are very, very close. I've been
And you want 50, how many times have you been arrested?
Um, quite a bit, but
Can you count?
yes, sir. It's 1, 2, I think 3 times here, and then once.
And are you on probation right now?
Yes, sir.
How long?
For 1 to 2 years. I think one year for early termination, and then 2 years for the full term.
Right. And you think that despite the fact that you're on probation for criminal conduct, that you should have equal time, 50% of the time of your son's life?
I do, sir.
And right now, how often are you seeing your other children?
I'm not seeing them at all, Your Honor.
Why?
I don't know why. She blocked me and won't take my phone calls, and I've tried to ask her why. And she says, "I'm not getting into that right now." And then about the same time they took my custody away, here is when she did it there. And it was about right back to back.
So right now, how often are you seeing your child with Aaron?
And then I'm not at all. I dropped my son off at school and we were 1 minute late and I dropped him off in the car rider line. Miss Brady said I dropped him off behind the school yesterday. And we were 100% in the car rider lane and he had to walk to the cafeteria door. And I sat there in the car rider lane and watched him go in the door. And I watched the door open and him go in. And they said that I left him there by himself, which I never did. And I emailed Miss Brady multiple times when it happened to tell her the situation. I think there was a case with DCF got involved and they found no wrongdoing.
Well, an order that was entered by Judge Turnbow in June of this year, this last month, says that you are to have supervised parenting time on Thursday from 5 p.m. to 7 p.m. and Sundays from 5 p.m. to 7 p.m. at the Eden Center.
Yes, sir.
Have you been exercising that visitation?
Yes, sir, I have. When it first started, I did miss the initial visit. I wasn't realizing it was that beginning of that week. And I also had, a lot of work going on that week because I do work for myself. And so after that one, we did get established. And there was one time on Father's Day, I was there and I was there a couple minutes early and they told me to park around back because there was a pending order of protection. And I guess so I waited till like right at 5 and I started to walk up and then there was one of her workers. I didn't realize it at the time, was walking out to her car and gets in her car and leaves literally right at 5 o'clock. And nobody answered the door and they said I was late. And I know I wasn't late. I was there on time. I was there early, a few minutes early. And then, so since then, I've had a witness go with me there just so that way, something like that were to happen again, I had somebody to witness it.
You were ordered by Judge Turnbow to take a 14-panel drug test.
Yes, sir.
Is that what you had yesterday?
Yes, sir.
You want to introduce that, you can get that.
Your Honor, that's the photograph of that, so I have a copy.
Yes, if you will demonstrate that.
And me and Miss Brady did talk about the 14-panel drug test cost upwards of $600 to $800. And after speaking with Miss Brady, she agreed to a 10-panel.
Your Honor, just so you know that part of it, that is, myself, not.
So you have a 10-panel drug test. This is a hair follicle test.
Yes, sir. And it goes back 90 days.
All right, mark that as exhibit. But you were ordered to take a 14-panel and you have not done it.
Well, I asked Miss Brady because the 14-panel costs so much, if a 10-panel would be equal to the same as, because I was agreeable to a 14-panel and they agreed to a 10-panel would be sufficient.
I'm not the one who ordered the 14-panel, that's the problem. All right. So if you're not seeing your children except for supervised visitation,
Yes.
and your child here from with Ms. Butler, you're seeing that child by supervised visitation, but you've not been exercising the supervised visitation, or you have?
I have, yes, sir, I have.
And that's at the Eden Center?
Yes, sir.
All right,
I've missed a couple of visits.
all right. And are you paying for that?
They said it's free there.
It is free. Okay. All right. Tell me what else you want me to do in this particular case.
So Judge Turnbow, they took away my custody. She made claims of me being on drugs. And I absolutely haven't been on drugs. For probation, they drug test me pretty regular. And then I also see a doctor once a month. And I get drug tested there, and I've been seeing him for multiple years, and I've never failed a drug test there. And so I guess there was an ex parte. They were to suspend my parenting time based on that right there, dropping my son off at school and just saying I was on drugs with no evidence or no, anything.
You heard your wife testify yesterday about some of the things that happened between the two of you and what she detailed as physical abuse that you've inflicted on her.
Yes, sir.
And she introduced photographs of bruises and on her face, and bruises on her arm. And there was this testimony about you trying to gouge your eyes out with her thumbs and so forth. Do you understand how that can concern me regarding you as a custodian for your children?
Yes, sir, I do. And I never intended to gouge her eyeballs out or anything. And I hope you would take into consideration, Your Honor, that night she did come after me a few times, and I left and ran out to the back door and tried to leave the situation multiple times. And also she's had plenty of time to think about what to say, because it was months and months later before she even went to the police. And I just I did do complete the anger management 26-week class, Your Honor. I did go to Cumberland Heights intensive outpatient program. And I also have been involved with individual counseling for well over a year. When I was working at YRC Freight before they filed for bankruptcy, that's how I lost my job. My insurance provided 1 week free counseling every week, and I took advantage of that. And that's honestly, Your Honor, what has helped me grow as a person and change my outlook and help me control my emotions and also be a better parent to my son. And also, going to the outpatient, I haven't drank alcohol in been a while. I can't tell you exactly how long, but it's been multiple years. And I hope with that, Your Honor, I have, and I've also coached my son's soccer team, and all the kids on his team loved me. Every time I would show up for soccer practice, they would run over and jump on me. And I've been actively involved in my son's life in a positive manner. With anything and everything he had going on, I was sure to be there. And there was couple of times when Aaron's mother wanted to be involved, and she wasn't a big fan of me, and I always supported my son's relationship with his grandmother. And I've always made sure to tell Aaron that, Gigi wants to come, I'll go somewhere else for a while. That way she can be involved as well. And so I'm also very supportive of everybody else being involved. And I'm a firm believer, the more people that love my son, the better.
Okay. Anything else?
Back in December, with that agreed order, when I was to get my son, and just I was there to get him and pretty much every time, and except for there was one time I was doing a job in Georgia, and I had broke down on the side of the road, and it was my day to get Ryan from school, and I couldn't call Erin to let her know that I was broke down. And I called the school multiple times. I called the daycare multiple times, no answer, left voicemail. And I ended up calling a friend of mine to go to the school to pick him up. And she went there and there was nobody there, she said. And that was can't remember the exact date. It was can't remember. But I think they did mention it yesterday, along with the on the 7th, when we switched weekends. She said I didn't show up, even though I tried calling Miss Butler to confirm, and no answer. And then also, with my other two children, Your Honor, when me and their mother split, we decided on a child support. We never went to court for a while, and I've always paid her on time, and I always got my other two children when we're supposed to. We worked things out fine, and it wasn't till, I don't know, a couple years later till we finally went to court, and I had always paid her before without even a court order, and I took care of my children and got them every single weekend I was supposed to. I mean, I'm sure there was a couple times where I did miss, and I mean, because it had been many years because of something happened or being out of town or what have you. But I've been actively involved in all my children's life and as much as possible.
All right, anything else?
Um, um, I'm sure there's something I'm missing, and I just hope the courts can see that.
All right, Mr. Brady, you have questions? If you'll turn that phone
Oh,
in. Wait a minute, he started something else.
about the I thought you meant like about the children, like with the stuff at the house. Your Honor, I don't ask for anything that's not mine. I don't want her retirement. I don't want anything that's not mine, and I would never ask for that. And the only things I would ask for is just that things get split equally. And because
When you say split things equally, what specifically are you referring to?
such as in sale of the house, just like my personal property.
You want to sell the house and you want half the proceeds, is that correct?
Yes, sir, I would. And I have made several attempts to, in the beginning, to try to give Erin money. We did have a joint account, and I told her on multiple times that I was leaving money in there for her. And then one time she did go up there, and she still is on the account. And I guess she tried to close the account. I'm not sure, but and so when I left the house, I didn't have a job, Your Honor, and I had been working for myself, and me and Erin came to an agreement that she was starting a new job.
Where are you working?
I'm working for myself right now, Your Honor, but I am looking for active employment.
All right. So when you say you're working for yourself, what do you do?
Diesel mechanic. I work on cars. And then I was doing a little bit of subcontracting in the beginning, but I since went back to just working on
How
cars.
long has it been since you had a steady job?
It's been about a year and a half, 2 years.
Is that when all these criminal cases started up?
Yeah, it's really hard.
So right now, what is your monthly income?
Oh, Your Honor, it varies. It could be $500 a week to like $200 a week.
And where
About
are
a
you
month.
living?
I'm living, a friend of mine helped me out, because I was about to be homeless. And he allowed me to stay in a house that he has and, that's empty to help me get back on my feet. It's not a permanent, solution. It's that so I can get a job, find a place to live, and, it's that way I didn't have to live on the streets. Um, so that's where I'm living at as of right now. And, I am looking for a place and a job. There was a couple of job opportunities that had come up.
What do you have at the house that you're claiming is your personal property that you haven't been able to recover?
Yes, Your Honor. I would like to get Bailey and Corey as my other two children. Their stuff that's in the house, like their bed, their clothes, their personal stuff, toys, if I'm allowed. And their like sports equipment as well. And so some of the stuff in the garage, like that may be theirs. I got toolboxes in the garage that I brought into this marriage that I had before. That I would like to get, and some tools in that garage I would like to get that I brought into the marriage, especially like my grandfather's tools. There are some tools that I did buy during the marriage, and if we gotta split, however, I'm fine with that. There is also a lift in the garage. It's not set up. It's laying down. It's a car lift that is not mine. It's a friend of mine's. I definitely would like to get that as well. And just stuff like that, and I hope you're taking consideration, Your Honor, that I pretty much had to start over, and it's I can barely afford to pay rent or on my own, let alone, pay a double, rent. And I did make several attempts to try to come up with a way to give her money or like that.
So have you been paying any kind of support to your wife?
I am not, Your Honor, and there was times where I tried to and she wouldn't take it.
Have you been paying any support for your other two children?
Yes, sir.
And how
I
much is-
did miss a few payments, Your Honor. I did. But before then, I'd hardly missed a payment until recently. Times have gotten pretty hard. And I just been trying to do the best I can. Especially with, like attorneys and all the fees, and I paid the probation, and it just completely drained everything. I also, leading up to this too, there was an inheritance that I got, and that I did give Erin $5,000 cash to pay her credit card.
When did you do that?
It was a few months before I left the house. So I hope you take that into consideration. I also, in the kitchen where we were gonna put the archway, I drywalled that whole wall. I bought a bunch of drywall. I just bought a brand new refrigerator. It's on my credit card, which I'm fine to keep credit cards. My debt's my debt. Her debt's her debt. I bought a bunch of baseboards, painted the hallway, painted the kitchen. Just did a bunch of work on the house. Bought new light fixtures for the kitchen. 2 light fixtures, and they were like $400 or $500 a piece.
Anything else?
Yeah. And then the mattress in our master bedroom I bought too. It was like $6,000 that I bought, and I did buy that during the marriage, and so I know that would have to get kind of split. And so YRC, my job, I worked for 10 years and they filed for bankruptcy. And so I never quit my job, Your Honor. Due to them file for bankruptcy, I did lose my job. I was getting,
Well, your wife testified, I think it was, that she thought you could make $25 an hour or more.
yes, sir. Yeah, I think it was like $24 an hour. Yeah.
And that was the last job you had.
Yes, sir. And then once they did that, me and her came to an agreement that, I would try to work for myself, especially with Ryan starting school. That way I can get him to and from school. And that way she could start her new job with no worries. And that's when, right before everything's happened. Yes, sir.
All right,
And,
anything else? All right, Ms. Brady had a lot to ask you some questions, so Ms. Brady, you may cross-examine.
Mr. Butler, I just have a couple of questions. So when the judge asked you how many times you've been arrested, do you know that it's been 7 times that you've been arrested, 7 different incidences?
yeah, I didn't realize it was that many times.
And- Go ahead. So, you were arrested January 17th of 2023 for aggravated domestic assault and false imprisonment. You were arrested May 13th, 2024 for violation of bond and resisting arrest. Does that sound right?
Yeah, I'm sure.
And then August the 10th, you were arrested for stalking and violation of bond. August 14th, aggravated stalking and use of electronic device. August 15th, aggravated stalking. And then most recently in May, on May 6th, you were arrested for violation of bond conditions in Cheatham County. And then on May 14th, arrested for reckless driving and aggravated stalking in Davidson County. So this has been going on now for 2 years, over 2 years. It started December of 2022 and has continued until just a couple months ago of a continual pattern of you being arrested because of things that you are doing to Miss Butler. Is that right?
Yeah, it's definitely being arrested sounds right, but being at a place where she shows up and me being arrested for never seeing her, and never even seeing her, I'm being arrested for, and it's been a constant attack on me since the beginning, a constant to try to have me arrested over and over and over. And there's body cam footage of that, a proof of that where,
Okay, and you have several convictions though as well. It's not just being arrested.
yes, ma'am, I did make the mistake of, taking the charge. My attorney was arguing with me that day and they ended up kicking us out of the courtroom because he was yelling at me to take the charges. That was
Who
the
was
last.
your lawyer?
It was attorney Nash. I gave him $10,000 that day, Your Honor, and I would never give him $10,000 to take a deal in one day.
So I want to ask you though, just to be clear, September 4th, 2024, you entered a plea and you were convicted of stalking, bond violation, and domestic violence.
I did take that deal, and I hadn't seen my son for months, and that's one of the reasons that I did want to take the deal, and so yeah, I ended up taking the deal because I was beat up over and over by attorney Nash, and I've made several attempts after that to appeal or put something in to take it back because I wasn't emotionally, I was unstable. He's over here attacking me to take this deal, and I ended up doing it. And so,
All right. And then here in May of 2025, you were found guilty. You didn't enter a plea, but you were found guilty by the court in Davidson County.
yeah, and I don't know why the attorney, I told him, and I've got the recording, the audio recording of when I met with him right before we talked to the judge, that we were to take all these charges to trial. And for whatever reason, one of them, he set for a bench trial. And he told me that we weren't, nothing was going to be decided today. Everything was going to get bound over. And at the very end, the judge said I was found guilty of violation. And, I had like my evidence and stuff. I didn't give any of it at all. I didn't bring it because I wasn't under the impression that everything was going to get bound over what he had told me from the beginning.
All right, and then I want to ask you a couple of other questions about where you're staying right now. Where are you staying? Where do you sleep at night?
Can I just clarify one thing from the question before? I did file an appeal for, to freeze the verdict, a motion, and I'm trying to take that one back and make all three of them go to trial because
Okay, so where do you stay at night?
yes, ma'am. I was staying right now in Pegram. There's a friend of mine that I do a little bit of work for, and he also gets a little bit of work from me. His name is Terry, and he has a house in the back of his house, and he said I could stay there till I can get on my feet. Or
Okay, and what's Terry's last name?
Woodall.
And did he happen to come with you today?
No, ma'am.
And in this house that you're staying in the back of his house, how big is it? What's it look like? How many rooms are there?
It's a 2-bedroom, 2-bath, 2-story. It's a pretty big house. I do have pictures of it I can submit for evidence.
And in this 2-bedroom house, does it have electricity?
Yes, it has electricity and it has water. It's in his name, because he knows that I'm having a hard time and he's just trying to help me out.
Does it have flooring? Does it have carpet? What's on the floor?
Yeah, yes, ma'am. It's tile. They just recently remodeled the house a few years back.
Is
There-
this the house that DCS visited?
Yeah,
And you haven't gotten a copy of the DCS report or anything like that, is that right?
no,
Do you have a written lease for this place?
I do not.
You have an oral agreement though?
Yeah, it's just a verbal agreement, yes.
And what are you paying for rent each month?
I'm not paying him anything for rent each month.
And he lives near this home,
Yes.
like on the same property?
Kind of. They are separate properties. I'm sure they're separate properties, but he owns that property as well.
Okay. And you've had visits with Ryan since the June 4th hearing at the Eden Center.
Yeah.
And you missed 2 of them with no explanation. And you were late for 2 of them, is that right?
I don't recall that. I was late that one time. I was thinking it was at 5:30. And I was also, I hadn't seen him in a while and it was hard to see him.
Okay, and I know today you brought someone with you. Who did you bring with you?
Yeah, that's Barbara.
And what's Miss Barbara's last name?
I think it's Woodall. Actually, I think it's different. I'm not sure.
Okay, and who is she? How do you know her?
That's Terry Woodall's mother. And I know her from church.
And does she live in the same community in Pegram?
Yes.
Does she live on the same property?
Her property's separate, but all these properties butt up together.
And she's come with you to some visits at the Eden Center?
Yes, ma'am. Since the on Father's Day when I was there, since that happened, and then also the Cheatham County Police have been pulling me over constantly, and for that too, so that way that couldn't happen.
Okay, and so, but she's come with you to those visits, so your son knows her?
Yeah, yeah.
And your Miss Butler has agreed to allow her to be at those visits?
Yes.
And you think that, Miss Barbara is, a good person to be around your child.
I do, as far as I know, yes.
So if the court decided today that you were gonna have, when you had parenting time with Ryan, if the court decided today that it would be with Miss Barbara present, how would that work for you? Do you think that would be acceptable?
Yeah, I think so.
All right, so then, on the, really the couple last little things, on the financial portion of this hearing, you said that you've made deposits into the joint account to try to help carry the cost of some of the home. Is that what, that was your testimony?
Yeah, well, in turn, I told Erin that I had extra funds in there to let her know there was money, to try to, but she was never taking the money out of there.
And so if we looked at bank records and it looked like you had deposited $8,574, think that sounds right?
Probably. Yeah, but also a lot of that money was for, like the parts or it wasn't 100%, profit, I should say. It was for, like material costs, that's bound in there as well.
I gotcha. And so if that same bank record would show that you deposited 8,500, but you withdrew 8,600 for child support, gas station, food purchases, do you think that sounds about accurate?
Sure.
All right, Your Honor, that's all I would have.
Also, Your Honor, Judge Turnbow, after the drug test results, he said that I could resume back to the 50% custody that we had before. If that was,
Well, I'm not there.
I don't know, you're not, but
The criminal, you're on 2 years probation and your 1 year probation. Are those running concurrently at the same time?
yes, sir,
You
and
got here out of Cheatham County,
yes, sir,
and
and
have they filed a probation violation against you because of this new case?
yes, sir, and
And
so,
when is it set to be heard?
in August the 13th, I've
So-
also, the Cheatham County, the August the 13th.
You understand that with a probation
Yes.
violation, if the judge in August finds you guilty, they can revoke that 2 year sentence and you could go to prison for 2 years.
Yes, sir, I do, and I just really hope they don't, and I was,
I'm sure you do, but I'm just telling you, I'm making sure that you understand what's going on.
yes,
Right,
sir,
thank
and
you. You can step down. You have any other witnesses? I believe it's rested as proof. Ms. Brady Wilkerson, do you wish to offer any other testimony? We're hearing closing.
Your Honor, as you can see from the court file and as you've heard in testimony today, father's parenting time was set to be supervised June 4th by order of this court, and that it would be reviewed on June 30th if the father had completed a hair follicle, which it was announced, or it was ordered that it be a 14 panel. And then also that he had a DCS walkthrough of his home. Then the court reviewed that on June 30th, and on June 30th, in agreement with Judge Turnbow, that was reduced to a 10 panel because it had not been done by June 30th. The drug test hadn't been done. And so that was reduced to a 10 panel. We've got that today, which shows a negative screen, but other than that, nothing has changed in Mr. Butler's situation since June the 4th. And so I would ask the court that he be left at supervised visits. There's been a no showing, no proof before the court that the home that he's in is stable. We have his testimony, but I would ask the court not to consider his testimony credible because he often doesn't even remember different things that have happened to him in his life. So however, though, Your Honor, we would ask for a change of the schedule. As you know, it's 2 days a week at a facility, and that's not sustainable for a long-term situation. I've talked to my client and she is agreeable, if the court is agreeable, to allow Barbara, if she's agreeable, to supervise that visit or supervise that parenting time. I know that's a little unusual since we don't really have her as, as a party or under an order of this court to do that, but that's something that we might consider, or we could say supervised by an agreeable third party, whoever that may be. However, that's going to be complicated because there's no contact between the parents right now based on the criminal case. So I'm not sure how to solve that problem for Mr. Butler, unfortunately. So there's that, but I want to go through, and I know you know this already, but I would just like to make it for the court's consideration, the factors in TCA 366106 that the court must consider. Obviously, strength, nature, and stability of the child's relationship with each parent prior to separation. There was a good relationship between both parents and the child. However, since then, there's been months where the father has been unwilling or unable to attend to Ryan's daily needs. He was either incarcerated, on the run from the police, or unavailable, didn't have a home. And so we would say that that factor weighs in favor of the mother. Second factor, each parent's past and potential for future performance of parenting responsibilities. As stated, Mr. Butler has struggled to fulfill these responsibilities. He's failed to pick up Ryan from school, dropped him off at the wrong places, and failed to maintain a stable home or job. So this factor weighs in favor of the mother. Number 3, refusal to attend court-ordered seminar is not applicable in this case. Number 4, the disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. As you heard Ms. Butler testify, Mr. Butler has, actually, Your Honor, we didn't discuss that. Mr. Butler has not provided evidence of stable income at this point. At the hearing with Judge Turnbow, he didn't know the name of his landlord, didn't know how much rent he was paying. He had no information about his home. We have his testimony today that that may have improved, but we don't have anything firm before the court other than his assurance that the home that he's in is acceptable. The mother, on the other hand, as you know, has maintained the home despite having no financial assistance or physical assistance from Mr. Butler. She has a job and has cared for the child. Therefore, that factor weighs in favor of the mother. The degree to which a parent has been the primary caregiver. We've already covered this. As you know, the mother has been the primary caregiver since at least July of 2024, when the father was court ordered to leave the home because of his own behavior. Except for the times when the father was exercising parenting time every other weekend, which was very sporadic. And even those periods were marked by failed pickups or problematic drop-offs. So this factor weighs in favor of the mother. Number 6, the love, affection, and emotional ties. There's no doubt that Ryan loves both parents, so that factor weighs equally for both of them. Number 7, the emotional needs of the child and his developmental level. Obviously, a child needs stable relationships to be able to develop appropriately. In a home and a relationship that is marked by extreme domestic violence, stalking, and repeated failure to follow a court order, this preponderates in favor of the mother. The moral, physical, and emotional fitness of each parent. Again, there's deep concerns about the father's fitness and his ability to parent the child. Therefore, we would say this weighs in favor of the mother. Number 9 is the child's interactions with siblings, as well as involvement with physical surroundings and schools. As you heard, the mother has continued to facilitate a relationship between Ryan and his siblings that are not even her own children. Therefore, we would say that this factor weighs in favor of the mother. Importance of continuity in the child's life. You heard that he's been in the primary care of the mother for at least a year. And prior to that, even then, the mother was the stabilizing factor in her life. She's maintained a job, maintained a home, and all of these things while the father, as we know, has had his struggles. Number 11, evidence of physical or emotional abuse to the child, the other parent, or any other person. This has gone on and on and on for 3 years. So we say that this factor obviously weighs in favor of the mother. The character and behavior of any other person who resides in the home. No one lives with the mother. The father has lived in various homes. He's been in this place for at least 30 days. We hope that he stays there, but we don't know anything about who may be in or out of that home. So we say this factor weighs in favor of the mother. Number 13 does not apply. Number 14, each parent's employment schedule. Obviously, we don't have any evidence of the father's work schedule. This factor may honestly be equal between the two of them because it sounds like Mr. Butler has some flexibility in his schedule. And that, Your Honor, would be all that we would have on that. As far as the child support calculation, we've submitted evidence of what the credit should be to the mother, what her income is, what we believe his income should be if he worked the job that he were able to work. And we would ask that you accept all of that testimony as credible and make that an order of the court.
You've asked me to assign an income to him that clearly he's not earning at the present time. That would more or less be setting him up to fail, wouldn't it?
Your Honor, I'm sorry to say that I think that our position would be he has the ability to earn that. He's choosing not to earn it that's a different story. And that's what he has been able to historically earn, and that's what he agrees that he has the ability to earn. Whether he keeps a job or doesn't keep a job, child support court runs all day long on that exact same story. So that's our position on that. As far as the marital estate, the mother already testified that she's fine to divide the contents. That makes sense, of course, to sell the home, to close the joint account, that her retirement would be her own. They keep their own vehicles, they keep their respective debt. And again, Your Honor, we're renewing our request that the father be responsible for the mother's attorney's fees, or at least a significant portion of that, because many of these hearings and many of the things that we've done for the last 2 years is a direct result of his criminal behavior. And the mother shouldn't have to suffer that. Thank you.
Butler, you want to make a last statement?
Yes, sir. Yes, Your Honor. So the drug test was court ordered to be before the 30th, Your Honor. And I did have the drug test done before the 30th. And we just didn't have the results. Miss Brady did say I didn't have it done. I did. We just didn't have the results. And I showed the courts the receipts of the drug test, multiple receipts where I paid for it. And I've always been willing to get my son Ryan. It's been a constant attack for little things, nitpicky things. And that's just how it's been on me since day one. And I've always made a good faith effort to work with Aaron. I have provided, because I did start over, so I had to buy my kids all new clothes, all new cups, all new toys, all new everything. And I slowly have been building that stuff up because she's made it a challenge for me to go to the house. They did take out an order of protection on me, not because of violence. There has been no violence since the original incident in 2022. I can't remember the exact year, Your Honor. And since then, I have been in individual therapy for a number of years. I did do the domestic intervention for 26 weeks, and I ended up going back there because I just like the counselors for individual therapy with them as well. I know I don't have a stable income, Your Honor, and I hope the courts would take into consideration that me and Mrs. Butler had a verbal agreement beforehand to not seek active employment, because of everything going on. And then I also took these charges, and I didn't realize how hard it would be to get a job after that. And it's been incredibly difficult. And so in December, there was an agreed order that I was to have access to the outbuilding. There is a shop at our house where I have a lot of my tools. I did a lot of my work there to make my money, that I was allowed access there, and never once was I allowed to go back there after several attempts of trying to do that, Your Honor. And then when they did take the bracelet off me, it was not even days later. They went and put that order of protection on me for nothing. And then the first court date for the temporary, she didn't show up, and they were quickly trying to put things off. And so when I did get, it was like 40-something% custody in December. There was one time I couldn't get my son, and I did call somebody to go to the school to pick him up, and she said he wasn't even there. And so, because I couldn't call her because of the order of protection. And so, there was just that one time, and when I did drop my son, I do want to make note of, Miss Brady saying that I dropped my son off in the back of the school. That was never a thing. And I've tried clearing the air on that since day one. And it was never in the back of the school. It was in the car rider line. And I know that she's been the primary custodian, but that's only because the false allegations of me being on drugs, they took away my custody, and I dropped my son off at school in the car rider lane and watched him go to the cafeteria. I watched him, and for that reason, I lost my custody. And I've been trying to get a discovery out of them for a very, very, very long time. I've had my discovery done last October, and they didn't turn theirs in until recently after filing for motion to compel, of a bunch of motions. And I want Your Honor, sucked a lot of the money out of me. And that's why I'm here today by myself. I know. So that's all I got. Thank you.
All right, we're gonna take our mid-morning recess. When I come back, I'll give you my room.
All right. All right.
I have considered all of the evidence in this case and the exhibits that have been made, and we'll make the following ruling. Clearly, in this case, the evidence warrants awarding Mrs. Butler an absolute divorce on the grounds of inappropriate marital conduct. Proof has been overwhelming that she has been subjected to physical and emotional abuse. The physical violence towards her clearly resulted in criminal charges against Mr. Butler, and I'll deal with some of that a little later. But she is awarded an absolute divorce. That leads me then to the adoption of a parenting plan. As Ms. Brady has gone through them, I'll not belabor them, but I have considered all of the factors set forth in Tennessee Code annotated 36-106 regarding the adoption of a parenting plan and designation of the primary residential parent. The first factor favors the mother, the strength, nature, and stability of the child's relationship with each parent. Clearly, Mrs. Butler has been the primary parent all along, but Mr. Butler's issues with having criminal charges against him and having supervised visitation currently are such that I cannot find that that factor is even equal. It must be attributed to the mother. Each parent or caregiver's past or potential future performance of parenting responsibilities. Again, I think that factor favors the mother. Mr. Butler had perhaps a good relationship and had been involved until he hit the last couple of years where it seems to have gone downhill pretty significantly. Refused to attend a court-ordered parent education seminar. I don't have any evidence that either of them have completed, or both of them must complete it within 60 days, I think, under the parenting plan. They'll have to complete that and file notice of completion with the court. Disposition of each parent to provide the child with food, clothing, medical care. Mrs. Butler has been the primary person to do that. Mr. Butler has not been supporting the child since he left. And as a result of that, I find that favors the mother. Again, paragraph number 5, which parent has been the primary caregiver, found that to be in the favor of the mother. Love, affection, emotional ties existing between each parent and the child, I found that to be equal. I know that Mr. Butler loves his child, but under the circumstances, clearly his behavior and the things that he's been engaging in are the very reason that he finds himself separated from the child at this point. The emotional needs and developmental level of the child's been exposed to a lot of abuse in the family. You may not think that a child of this age would retain those things or that it would impact them. But it clearly, in my opinion, creates memories for this child that will bear with it probably most of its life. The emotional needs and developmental life of the child favors the mother. Moral, physical, and emotional fitness of the parent. I have concerns, obviously, about Mrs. Butler staying in a situation or reuniting with Mr. Butler after some of the physical violence and things that occurred. But that's a common thing, unfortunately, in domestic violence cases. It's not unusual to have someone who's been a victim of a domestic violence case who would take back their abuser or submit to their abuser again over and over and over again without trying to get out, because they have reasons. They have logical reasons that they think justify them trying to overcome or think they can fix the situation. In any event, I do find that this favors the mother because clearly both in the history that has been testified to and the criminal cases that are pending and the court's observations of Mr. Butler are that this factor favors the mother. Child's interaction in a relationship with siblings, obviously I think there's been a good relationship between this child and the other children that Mr. Butler has, and I would like to see that continue. The importance of continuity of the child's life favors the mother clearly. Evidence of physical or emotional abuse to the child or the other parent, clearly that favors the mother because there is verified and absolute proof of the physical abuse of Mrs. Butler by Mr. Butler. Character and behavior of any other person residing in the home, I don't have any other information about that. And as a result of that, I don't find any of the other factors that really weigh on my decision. So based on all of those, I found that those factors favor designating Mrs. Butler as the primary residential parent. So where are we then regarding his visitation? I know that there was a schedule that was in place before. However, I'm very concerned because I do this on a regular basis. Mr. Butler has his own probation for 2 years by his own testimony. By his own testimony, he has a pending violation of probation. That pending violation of probation might very well return him to or send him to prison for 2 years, or at least to jail for some period of time. And as a result of that, I am not in a position where I am comfortable with awarding him unsupervised visitation. In my opinion, I understand what he says about the situation, but it is, in my opinion, my job is to protect the best interests of the minor child. So I'm going to order that there be supervised visitation. He does not have to exercise it at the Eden if both parties can agree on an alternate supervisor, but it will be exercised under the supervision of another person. Miss Brady Wilkerson, you had indicated that there needed to be an adjustment because she was relocating. Is that correct?
Travel. So really,
Well, my inclination would be that we do it every other weekend, and we do it from Saturday at 9 o'clock to 5 o'clock and Sunday at 9 o'clock to 5 o'clock. We'll have 2 full days with the children every other weekend, just not have overnight visitation at the moment. This schedule will stay in place until after, it'll be subject to review after Mr. Butler's criminal cases are resolved. So what I'm telling you, Mr. Butler, is this is right now being in supervised, continued supervision because you have pending criminal charges that could very easily upend your entire life. Once that has been resolved, you are free to apply to this court, and it doesn't require material change of circumstances. I am putting that in this order that allows you to come back to court for a review and possible revision of your visitation with the children once you get your criminal stuff worked out. Do you understand that? Now, obviously, at that point, you're probably going to be subject to drug testing again, and the probation department may be doing that to you anyway. But I'm giving you an opportunity to try to modify this and go back to something else once your criminal charges are resolved. At this point in time, will calculate his child support based on her income of $6,000 a month, which is testified to. And you've asked to impute income to him of $25 an hour. I do not find that right now that's verifiable, but the child support guidelines do provide for imputing income. I think for a male, it's $39,000 a year. So if just check the child support guidelines, I will impute it as, I think it shows you where, how long it's been since I had to do it. But anyway, it'll be imputed on that basis rather than the $25 an hour. And again, that's subject to review once he's fully employed. He'll be given every other weekend as a credit for days. So I'm going to recommend an order in this that the parent parties, I know there cannot be direct one-on-one communication, but there's this parenting app that's out there that they can utilize. She can make him aware of the children. They can communicate through that. And that, in this court's opinion, will not constitute a violation of the order, no contact order. Ms. Brady is familiar with that. She can help you with that. As I said, this will be subject to a review and possible modification after you get the criminal stuff worked out. Now, how that happens between now and then depends on you. You've not had very good luck in getting yourself straightened out to stay away from getting arrested. And if you get arrested on something else, then that's going to make a difference as far as this court is concerned, what happens in the future. But that is the order regarding the shall maintain the medical insurance and be entitled to a credit on the calculation for the medical insurance. There is a retroactive child support order that would have to be in place from the date of filing of the divorce until it goes down. And that'll have to be calculated. Moving then to the property division. That's part of the requirements of the child support guidelines. So yes, it will be included. Going to property division, the house, I think both parties were in agreement the house is going to have to be sold. So as a result, we'll sell the house. I'm going to order that the proceeds after payment of all of the debts be divided equally. However, any request for attorney's fees that Mrs. Butler had to have to be deducted from the proceeds that Mr. Butler would otherwise receive for his share of that. I declined to order him to reimburse you for the payments you've made for the house. I know you were asking for $11,000 from his half of the house payments. You were living in the house for one thing, but I'm also going to offset your claim against his claim for your portion of your 401k proceeds. You'll be awarded those 401k proceeds, and that will offset any claim you have for him having to reimburse you for house payments. Each of them will be awarded the vehicles in their possession and be responsible for any debt on them. Each of them will pay the credit card debts in their name. She'll be awarded all the household goods, furniture, and furnishings that are located within the house. Anything he's acquired since the separation in the way of household goods, furniture, or furnishings that he's had to acquire, he'll be awarded all of that. I'm going to order that he be awarded his other children's clothes, toys, etc., personal items that those children have. He'll be awarded the sports equipment that he had mentioned that belongs to him. I'm also awarding him the toolboxes and tools and car lift. The reason I'm doing that is because obviously I'd like for him to get back to work as a diesel mechanic, and that needs to be done. He needs tools to be able to do that, my understanding is at least. Ms. Brady, you may submit your claim for attorney's fees for this court for review. Clearly, the law would allow that to be awarded, but as I said, it will have to be offset against the interest he has in the house. Mrs. Butler will be authorized to, on her sole authority, have the house listed with a realtor and go ahead and try to get it sold. She'll be able to negotiate all that, but that will be subject to the court approval for the sale of the house. As the judgment of the court in this case, costs in fact to Mr. Butler. These that I don't want her to sell the house for next to nothing. I want, when she gets this offer, she lists the house And she needs to list it for the price recommended by the realtor. And then if you get an offer that's less than that, then she just needs to come back in front of any of the judges to get an approval of that with notice to Mr. Bowles.
Then also, Your Honor, one last thing for the record is that the countersuit filed by Mr. Butler would be dismissed.
It is dismissed.
Thank you, Your Honor.
Well, it's up to you as to how the future goes for you and your children, your child. I hope that you'll make sure that you successfully defend this probation violation hearing, and you can come back down the road and try to get your residential time reinstated.
How do I do my stuff on the house?
Ms. Brady you'll have to get in touch with Ms. Brady and arrange that, since you'll have to probably. Right, it'll have to be done with probably a civil standby by law enforcement.